Hey guys, my name is Amaan Ahmad. I'm a legal intern at LEXIS and Company. I'm pursuing 3 years law faculty of London University, and the topic of my today's video is the pre-stage trial under the CRPC. A step-by-step procedure I will explain in this video very briefly, and how a person reaches to the gates of the court and the process behind it. So, the birth of a criminal case, if we talk about, so every criminal case originates from the commission of an offense, and the illegal proceeding against it are started when it is informed to the police, generally by way of informant. The informant may be a victim, someone on the victim's behalf, or anybody having information of the offense. The offense may be either cognizable or non-cognizable. So as defined under article 2 clause 6 of CRPC, a cognizable offense is one in which a police officer may arrest without a warrant. So contrarily, as per section 2I also, a non-cognizable offense is one which police officer has no authority to arrest without a warrant. So the steps involved in the pre-trial stage are the first and the foremost is information to the police, as I've already talked about. So information on cognizable offense. So if the offense received by police through the informant relates to any cognizable offense, the officer in charge of the police station records it under section 154 of CRPC. The informant can give the information in both oral form or written form, or he is even in the oral form, then it is duty of the police officer to make it into a writing. So the record piece of the information received first hand from the informant is called FIR, or first information report. The FIR is the first version of the incident as repeated received by the police. It is vital for both the investigation and corroboration of evidence, but it is not substantial evidence in itself. The criminal law sets its motion upon the logic of an FIR. Then information on non-cognizable offense, if the offense is non-cognizable. So these are usually less serious offense. So upon receiving the information, the magistrate may take cognizance of it under section 190 CRPC. If he take cognizance, he examines the informant upon oath. The examination substance is reduced to writing and signed by the informant and the magistrate. So after examining, if the magistrate finds a sufficient ground to investigate the case, he orders the police to investigate under section 156 and 202 of CRPC. If not, it dismisses it. Once the police receive the magistrate's order to investigate, they carry on with the case as if it was a cognizable one, although they cannot arrest without a warrant. So what if the police refuses to record the FIR? What would you do though? So at times the police may not lodge an FIR to avoid their workload, or if the police officer opinion no sufficient ground exists to enter into a investigation. So what is remedy to given to you? So according to CRPC, send written information to the concerned SP of Superintendent of Police under section 154 clause 3. So is the SP satisfied that the information discloses the commission of any offense, cognizable offense, he order the police to investigate. So file a complaint. Secondly, if to the magistrate under section 190 CRPC, which gets treated like any information received of an non-cognizable offense under section 190. Then the last is file a zero FIR in M police station other than which we refuse to file the FIR. It was given in Kirti Vashish versus State and others. Landmark judgment according to zero FIR. Then the station that files zero FIR conducts any required medical examination and transfer it to the proper police station which have proper jurisdiction. Then the next step is the investigation step. So report to the magistrate. Upon receiving the information of cognizable offense, the officer in charge of the police station sends a preliminary report to the empowered magistrate through the superior officer appointed by the state government. Then proceed to the spot. So the officer in charge will proceed to the spot. He suspects the commission of an cognizable offense or receive the magistrate order to investigate a non-cognizable offense. So proceeding to the spot where the crime is actually hasn't not been identified. If the case is not serious or the information is given against any person by name. So attendance of witness. Though when the police officer suspects the acquaintance of any person with the case at hand, he may give a written order under section 160 CRPC for that person to appear before him. So this to facilitate the police to collect the required evidence, and the so-called witness is duty bound to oblige the order. So the order is part of the investigation, doesn't amount to harassment of the witness or violation of article 21. So however, the following person need not attend the police station. They are male under the 15 or above 16 years of age, a woman, and mentally or physically disabled person. Then there is examination of person. Usually the police examine the witness orally and reduce the person into writing. Every statement, witness statement is recorded individually in first form. It can be ordered or video recorded too. So the witness is legally bound to truly answer all the questions put forth him during the examination, except the one that may expose him to any criminal consequence. Then there is a prohibition or signing the recorded statement. No statement made to the witness of the police recorded in writing while investigation is signed by him under section 162 clause of CRPC. Such statements can be used by the accused or the prosecution to contradict the witness under section 145 of the Indian Evidence Act. So meaning if the witness makes such statements come as the prosecution in the trial, then the accused can contradict him also using such a statement. So you have to be very careful at that stage. Or if as a defense witness in the trial, then the prosecution can contradict him suing such for such statements. But it cannot be used for corroborating by the evidence, corroborating evidence of a witness in the court. It was also given by a landmark judgment. Then recording of a confession and statements. So, however, 164 CRPC provides the exception that such a recording must fulfill the following condition to be admissible in the evidence. Once a or a judicial magistrate must record the confession or statement during the investigation, the recorded magistrate must be certified that the confession is voluntary. The magistrate must warn before the recording confession that the accused is not legally bound to confess, and if he confesses it, then it will be used against the court. So then the recording must satisfy the section 281 of CRPC. It could be recorded by audio video means. Also the presence of the accused advocate is required. So then if there is a rape victim, so medical examination has to also be done by the before the trial stage. So searched by the police, then if the reasonable ground believes that it exit that will be found in the place, and he opines that it is an obligation or a duty of the police to search the place, then the police would have to search for it and write it into the report. And then the arrest of the accused while investigating a non-cognizable offence. If an arrest is felt necessary, the court can issue an arrest warrant under section 70 CRPC to tell the person to come to the court and give the reason why was he not appearing in the courts. And however, while investigation of cognizable offence, the police officer arrest without a warrant under section 41 CRPC. So any person against whom a reasonable complaint is filed, credible information is received, or reasonable suspicion arises that he committed a cognizable offence, punishable with imprisonment up to 7 years, fine, or both. So what if the investigation is not completed in 24 hours? So the police cannot detain anyone who is arrested without a warrant for more than 24 hours. So such detention exceeding 24 hours amount to illegal arrest and violation of Article 22 Clause 2 of the Indian Constitution. But no constitution can be practically completed within 24 hours. So section 167 CRPC provides the solution to the dilemma as what to do to the detained accused. So under the above circumstances, the police forward the accused to the nearest judicial magistrate along with the copy of investigation diary maintained under section 172 of CRPC. Such magistrate can extend the police custody for 15 days, but not more than 90 days, or for an offense which is punishable with death or imprisonment life, or not less than 10 years, or for any other offense it is only extendable by 60 days. Then there will be report for the investigation. So the subordinate officer involved in the investigation submits the report under section 168 CRPC to the officer in charge of the police station, who further forwards a completion report to the magistrate under 173 CRPC. The completion report is of two types: closure report, and the second is obviously the charge sheet. Then all the content in the completion report should be given: the party's name, the nature of the information, the witness name, the possibility of the offense, the accused name, where the accused were arrested, why he was arrested, the reason. So all this has to be mentioned in the charge sheet. So some special protection are also given to the women under section 354 or section 354 A, B, C, D, E, F up to E, or 509 CRPC are especially protected. For example, if the woman victim is the informant, the information recorded by a police officer. So all types of safeguards are also given. So this was all I want to say about this video. Thank you guys. Please remember, this video does not violate any guidelines of Bar Council of India, does not solicit to promote any of the video, and the sole purpose of this video is educational. Please subscribe to the channel if you haven't already to see more of this videos in future. Thank you.